I'm James Klobuchar, partner with Gearhart Law, and I'm here with my colleague and partner Jim Francis, and we're here to talk a little bit about software, and in particular, open source software. Perhaps unsurprisingly, this is a hot issue in today's market, and we're going to talk about some of the questions that we get most frequently from our clients. So without further ado, probably the most frequently asked question that we do get is, do I need a license to use open source software?
And this is where a lot of confusion comes in. Open source software always has a license associated with it. And people just don't seem to understand sometimes open source does not equal public domain. It's still licensed. The original coder still has rights to it. And you have to stay within those license terms. Otherwise, you could be violating the copyright.
Jim, that's really interesting. I mean, can you tell us maybe a little bit more about that? And if there's a real life case that you've been involved with, or a particular court case that comes to mind to drive that point home, maybe you can expand on that.
One issue I've run into, I had a client sued one time for using open source, and part of the deal with open source is it has to be available to third parties. You can't hide it behind a wall. So he used the open source and didn't realize it had a clause in there that said no commercial use. Well, he was creating proprietary software for a client and eventually got sued for copyright infringement because he exceeded the terms of the license. Another issue I've run into with another client is he was selling software to a food manufacturing company. And essentially the software contract, which was about 30 pages long, had a clause buried in it that said, you guaranteed that you were not using open source software. Sophisticated clients will always have that clause in there. So you could wind up not only violating a copyright, you could actually violate your contract with your customer. That's important because if there's a lawsuit, the customer more likely than the coder is going to be the target of the lawsuit. So you have to be really careful. You could ruin some great relationships and also have to pay back a lot of money. It's just not worth the risk.
That's really helpful. And I think it does drive the point home that there's always going to be a license associated with open source software, and understanding the license is going to be paramount for how you use it moving forward. Are there situations when it is important to not use open source software?
The principal place you just do not use it is if you're creating proprietary software. If that company wants to own the software and not have to share the code, you're going to have to draft from scratch. And I've had clients that went down this road and used open source, and when they saw the contract, had to back up and rewrite pretty large sections of code without looking at the original open source. Because if you look at the original open source and you try to emulate it in new code, you're just creating a derivative work, and it's still going to be a copyright issue.
One other question that we often get, and we've kind of touched on this a little bit, but when is it important to have a license, or what terms should we be on the lookout for in that license?
A lot of people modify what we call GPL licenses, general public license, and they insert little things into it like not for commercial use, not for use with certain types of products, not for use with certain types of software. Those little modifications are often put in there by what we call copyright trolls, who will make open source available but have something buried in the license that's going to ensure that you actually violate that license and create a copyright violation.
That's interesting. And just so everyone's aware, when you use the term copyright troll, what are you referring to?
A copyright troll is someone who is setting up innocent third parties for copyright lawsuits. We have them on the patent side, we have it on the trademark side. They exist in copyright as well. Their ultimate goal is to have somebody with deep pockets violate the copyright so they can sue them.
And I mean, if you find yourself on the wrong end of a lawsuit from a copyright troll, I guess for starters, how do you identify them being a troll? And then how do you best remedy the situation?
Copyright trolls tend to have long litigation histories. You'll see where they've sued multiple parties in multiple jurisdictions. And if you see a laundry list of defendants, then more likely than not, they're going to be a copyright troll. The only way to protect yourself is to use code from scratch. You can use open source, but again, you have to be aware of what's in the open source license. There are 4 typical open source licenses, each one with varying degrees of strength. that cover certain things. Sometimes it's a hardware lockout. Sometimes it's going to be whether or not you can use it over a network. So you have to be careful to know which license applies to which piece of open source. And not only that, if you use multiple pieces of open source, you may not be able to use open source under, say, a GPL2 license with a GPL3 license. You might be prohibited from that. So there are all kinds of things to look at.
That's interesting. And, when it comes to those different licenses and trying to get investors, for your company, are you better off served just ensuring that you don't use any sort of open source software? Or are there certain licenses out of those options that you mentioned that maybe are more attractive or palatable for investors when they're doing their due diligence?
There are weaker versions of the GPL. It's called the LGPL, the Lesser General Public License, which gives the end user much more rights to it. But ultimately, if you have investors, if they're savvy, they're going to want to know it's proprietary code as well. And if it is open source and you've told them it's proprietary, then you've got a new set of problems on your hand. It could be considered securities fraud. And I've had clients that went down that road and didn't realize that somebody on the back end did something that created a problem. And the next thing they knew, U.S. Treasury was investigating them for raising money on something they didn't own. So it does carry a lot of risk. That's why I generally recommend if you're going to use open source software and you really, really want to use it and have to use it, you take a look at the license. You have an attorney review the license, let you know what you can and you cannot do. Because at the end of the day, it's cheaper to take care of that up front and avoid the litigation than come to us later and say, hey, I've been sued. At that point, it's too late. It's going to cost quite a bit of money.
Yeah, this question is probably related a little bit to the same question on investors. But, when you go to sell your software, are there any types of restrictions that you may have or face that could be part of the license or even related to the license in some fashion?
A lot depends on why you wrote the software, who you're selling it to. You may sell it to one client who says, I want an exclusive license for this industry range. It could be food processing. That leaves you open to sell it for something else, but just not food processing. So there's all kinds of caveats customers can throw on that. Again, you just have to be aware of what you're doing, why you're doing it, who you're doing it for. It's just filled with landmines.
Thanks, Jim. It's been a really good discussion here. I think that's all the time we have, today. But, my name is James Klobuchar. I'm a partner at Gearhart Law. I've been here since 2013. And while my background's in biochem and molecular biology, I handle all facets of intellectual property law. If you have any questions on what we've talked about today, you can, of course, reach out to Jim, who will share his bio momentarily, but you can also reach out to myself. My email is james@gearhartlaw.com, and our main office number is 908-273-0700.
And thank you, James. My name is Jim Francis. I come to Gearhart Law after 20 some years of being with different firms, but most importantly, I have an extensive background in industry. I worked for a large international consumer products company for the better part of 20 years. So I've seen the entire product life cycle from ideation all the way to when you're going to kill a product. Given that perspective, we can also see things from the client's perspective as well. But again, if you have any questions, reach out to Gearhart Law. My email is jim@gearhartlaw.com, and my phone number is 859-519-0755.